Hi, this is Erica Merrill, and I'm the founder of Perfect Legal Video. I'm very excited to have with us today Attorney Nicole Reeves Lavallee. She has a family and real estate law firm in the Worcester area. We're very fortunate to have her with us every week talking about different topics that have to do with her two fields of expertise in the law. And today we're talking about something that I've never heard of. So Nicole, welcome. Thank you so much for joining us.
Thanks for having me.
You're welcome. So, this is why we have you here. There's always something new. And so, today we're going to be talking about what is a pathway conference, and it's something new that they're trying in the Worcester area. I'm not sure if they're trying it anywhere else, but let's talk about what it is.
Well, it's exactly what you said. It's offered in Worcester. It's a pilot program, which means we're the guinea pigs, if you will, to see whether or not this new system works. And so Pathways has basically three different tiers. You have Pathway 1, 2, and 3. And you're going to start out with Pathways 1. And it's a conference that is filed in any modification case. So the moment you file a modification, regardless of what type of reason it is, whether it be child support, custody, parenting time, any of those things, you're going to automatically have a Pathways conference. So you have to attend this meeting.
Now, I've heard of them saying, the court saying, hey, before you come in here, you need to try to mediate this. So that's similar to this, but there's just, I guess, a pathway of escalation, if you will. Is that right?
A little bit. So it's basically a hybrid of that. It could be a four-way conference, similar to a four-way conference, but it is also held by the court. So it is a court hearing scheduled by the court at the court's direction, and we all attend. So whether it's three people, two people, or four people, including the attorneys, going into this conference. The other person on the other end of the conference is going to be an ACJM who works for the court. Now, this is all done by Zoom. So all of us are sitting in our own offices or in the conference room with our clients, but we're on a Zoom meeting, and that meeting is recorded. So they will say, witnesses, raise your right hand, get sworn in. You're actually on the record. There's a recording of it. And you, as your attorney, will present your particular case. I filed this modification because I'm looking for alimony. I filed this case because I need to have a change in the parenting plan because it doesn't work because of X, Y, and Z. And obviously the other party would do the same thing. And then the ACJM would then try to negotiate a settlement with you. Or alternatively, they'll give you little tidbits, advice, maybe put you in a breakout room, and then ultimately schedule you for another hearing if they can't resolve it.
Wow. So really the difference is that, like, I know that I did a mediation, I don't know, 5 years ago. We've probably done a couple of mediations in the history of you and me, but there's no recording of it. And in fact, they'll say you can't bring anything up in court that happens here in the mediation. And so can you bring it up in a later case, or is it just that they have access to this information and it's just kind of background information on what you've done to try to negotiate in the past?
That is a great question. I'm 90% confident to say that I could get an audio because, again, if they're recording it, they've got to be able to give us, as attorneys, a recourse to go, hey, look, they just said in Pathways 1, X, Y, and Z. I want to use that because now it's an admission. So I would certainly say that their recording of it and it being a court document and us being sworn in certainly should be able to be used against them. Where again, yes, in a traditional mediation, no recordings, no notes, no nothing is leaving these four walls. So definitely a different approach, but I would say I'm pretty confident that if I wanted to get the records, I could get the records.
Well, I mean, I think that's great because then what the hell are you doing with that other mediation? I mean, maybe you come up with something, maybe you don't, but it always seemed a little sleazy to me that everything that happens in the mediation can't go on if you end up having to go to trial or further court dates. It's a lot of money to do that mediation. So, like, why can't we use it? You know, a lot of time and effort went into preparing for it. One would assume that things haven't changed. I mean, maybe you shouldn't assume that, but most of the time, I'm sure you're still trying to fight for the same things.
Absolutely. And I think, the key point there is that you're going to have, an ability to listen to somebody from the court that's going to say, well, maybe you need to think about this. And what about this avenue? Where, again, as a traditional mediator, they just go, well, what do you think? What's your worst case scenario? What's your best case scenario? They can kind of, well, how does that make the other person feel? Where you're going, I don't give a crap about the other person, right? But here, they're allowed to at least give you some tidbit of the law and going, really? You think the judge is going to do that? And they'll say it in a nice way, of course, but it certainly pushes you along further, I think. And that's their goal in this program, is so that they can get more people to resolve their cases and not have to continuously have a hearing and more hearings and more hearings and eating up the court's time, where now you're actually eating up somebody else's, and that's their only job right now to do.
I mean, that sounds like way more cost effective on both money and time for everybody. And it sounds like it would be a great program if it works out. What's the second step of the program?
So if you can't work it out in the Pathways 1, you go to a Pathways 2. So Pathways 2 is where you're going to go to the courthouse, in person, obviously, and you're going to go to the probation officers. So you're not going to see a judge. You're literally just going to go into probation, have a session with them, see if you can work it out with them. Again, they're going to know the specifics of a judge. They may have some insight that they were given, and I don't know this for sure, but they may have some insight that was given by either the ACJM and or the judge in regards to this case. But certainly they've been doing this every day. This is what they do, and every kind of case we have. So they can put their insight, and then again they try to resolve it, and they've blocked out a lot more time. Like, they're literally blocking out an hour, 2 hours for these. So you're getting to spend a lot more time than you would in a divorce on a temporary order. When you go into probation, you get 15-20 minutes to make your argument and see if there's any wiggle room, and if not, they're going to send you off away. In this Pathways 2, they really take the time to divulge into that. Is there a way that we really can settle that? Can we do something with it? So it kind of gives you better feedback.
I mean, I think that's great because I know when you go to court, you're often looking for that feedback, and you have to go in and have these pre-trial sessions with the judge, and you're hoping that you get feedback there. And now you can really figure out how to proceed, because it's not always certain that you're going to get the feedback with the way it works out now. And you don't know the reasoning behind it, and things might be different from one time that you're in court to the next. So, I mean, hopefully this would help out with the consistency of the life of your court case.
Absolutely. And I will say this, to go from Pathways 1 to Pathways 2 isn't necessarily a one and done. Sometimes you'll have 2 or 3 Pathway 1 sessions just because you're both pro se, or you need more information, and we've really done nothing. Oh my God, what do you mean we got a hearing already? So again, they're going to gauge whether or not you're going to go to Pathways 2 or Pathways 3 at that first session, but it may take a little bit longer. So I do think, all of these things stepping along are helping people to resolve their issues.
That's fantastic. So, what does the pathway 3 look like?
The Pathway 3 is we bypass probation and we go immediately into the judge. So it's basically at that point kind of a pretrial. I mean, I would say for all intents and purposes, we're going to treat it as a pretrial. We're going to write a Pathways conference memo which is identical to a pretrial memo. Hence, we're assuming it's going to be a pretrial type mentality. And obviously, at a pretrial, again, depending on who our judge is, we're going to put our best foot forward and we're going to present our case to the judge so that they're going to hopefully rule in our favor, or at least give us feedback in our favor. And obviously, the other party is going to do the exact same thing. So, again, that goal is if we can't resolve it, we're going to get feedback from the judge, and then maybe we can resolve it at another hearing, or maybe we can just walk out in the courtroom and resolve it there. So there's definitely things that we can do, but obviously, again, the goal is to resolve it at the first Pathways 3 conference.
I mean, that's good. In a way, though, it seems like they're adding a lot of extra steps, but if it works better, then great. Because I guess how they have it now with the mediation, there's really not a lot of push to get that decision to happen in that mediation, right? I mean, am I right in assuming that?
I think you are. And I think, the one thing that really helps, I think, in this is that while you're ordered to have a four-way conference, very few actually do it. So unless you're forced to do it, this basically forces you to do it. And the whole point of forcing you to do it is to listen to the other side, get their information, figure out what it is you could negotiate, and move on. And so it definitely gives you a pathway to go, oh, I may hate their opinion. I may think that they're absolutely out of their mind, but at least I understand where they're going with it. So even if you don't resolve it, I think it's very insightful for people to be able to at least gauge how they want to proceed with their case.
I mean, that's great. So, do you see this as working out? I don't know if you can even say it publicly, what your personal thoughts are on it. It sounds like there's good and bad.
There's definitely good and bad. I mean, I had one client that we're still in it, and this is year 3. So it's really frustrating because they were 2 pro se litigants, and they didn't know how to get out of Pathways 3. And when it started, unfortunately, I'm sorry, when they couldn't get out of Pathways 1, and when it started, they also never got a next court date. And we always leave Pathways whatever to go to the next Pathways with a court date. So that they were like literally the pilot of the pilot. And because they were pro ses, it kind of went, we don't know what to do with them. And they just didn't do anything until I got involved. So sometimes it has those hiccups, and you're like, no, no, no. And I literally had to file a motion to amend and file an answer and counterclaim. And the judge said, oh, but this is a Pathways. I'm like, no, it's been sitting there for 3 years. I need to become a Pathways 3. And the judge goes, oh, yes, yes, yes. Because they didn't know. And again, nobody knew how to get it to the right spot. And then there's other cases where you actually get it resolved because one party refuses to move the Pathways 1 conference. And so it forces you to go into that. And then people are making offers. And you're going, wow, I didn't know they were actually going to make those offers. But because, again, you wouldn't have had that conference had it not been for the Pathways, you're resolving it, and you resolved it in under a month and a half. So it definitely has its pros and cons. And I think realistically, from my perspective, if you have an attorney with you, you're going to be much more successful using the Pathways.
Oh, without a doubt. I mean, you should have an attorney with you. If you're not an attorney, or if you're not a family law attorney, or even like it really, everyone should have a family law attorney, even if they are a family law attorney, because you don't know what's going on. You're doing something completely new. People are getting stuck. They're wasting time. It's frustrating. It's even if they didn't have this Pathways, I've always said it's so great to go into the courtroom with you because you actually know what this is all about. You know what the next steps are going to be. You can actually gauge what's going on with the judge and with the case and give an honest answer on what you think. And, hopefully your client is reasonable and listens and you know what they want, but hey, realistically, it's going to happen or it's not going to happen. But I mean, it's so much better. And even though there is a cost to having an attorney, it actually saves you hours, hundreds of hours of worry and stress. It saves you a lot of money too, because depending on what your issue is, maybe it's child support. If you can't get your child support increase or decrease, or, depending on who you are and what side you're on, I mean, it can make a big difference in your life. So, uh, there's just a lot of different things that attorneys can help with. So definitely call Nicole and her team if you need someone to help you through this stuff. And if you're in the pathways, that's totally new. Uh, they're all figuring it out together, but it's way better to have an attorney that is in court every day and can help you get through and knows what questions to ask the right people.
Absolutely. And I think, that's the key point is, we've experienced this. So even though we, originally are kind of rumbling through it and going, what's going on? I don't understand. Like, because they don't really explain some of these things to us. But guess what? After we've gone to our second one, we're very versed in this. Even the first time, we might even be versed in it. And you're probably coming to me, and this is your first time. Do you know how many times I've done them now? So again, just think about that experience that I have for a whole new program that's out there.
Well, that's great. Is there anything else that we should know about pathways before we go?
Um, be forewarned. When it's a pilot, it's probably going to go to your county too. So while you might not have it because you're outside of Worcester County, chances are you will get it or you will get a hybrid of it, which is probably a better version since we're the guinea pigs. But you're going to have that. And so be aware of it and know what to expect from it. And ultimately, like I said, find an attorney that knows how to do this.
Well, thank you so much, Nicole. Really appreciate your help. And we are going to look forward to seeing you next week with a brand new topic. Thank you, everyone, for listening. And thank you so much, Nicole, for being on the show.
Thanks for having me.